or took her one day to realize what the expectations were.
Oh, wow. This courtroom went from calm to chaos in seconds. A defense lawyer comes in thinking he can outsmart the judge. Bad move. He misquotes a case, makes a false claim, and tries to get the judge kicked off. But Judge Simpson, he's sharp, experienced, and not afraid to call out lies. You can feel the tension building. Let's watch how it all unfolded.
Is that what you really want to tell me?
I had no help.
I've been doing this a minute. Court calls the case, People versus Anthony Johnson.
Alison, on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Johnson, who appears to my right. Mr. Johnson, can you put your name on record?
Anthony James Johnson.
Your Honor, we submitted a waiver request on this.
All right. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants found over circuit court on counts 1 and 2 with 3 following.
Acknowledge receipt of information, Your Honor. Wait for my reading, stand mute at this time.
Defendant every way for reading, standing mute to all counts. Court will enter not guilty plea. Pretrial will be set for
June 17th, 1:30 before Judge Cumpy.
June 17th, 2025, 1:30, Judge Cumpy.
And Your Honor, we can address bond briefly.
Okay.
That's far out.
It has come to my attention from the victim, she sent us a screenshot that the defendant has sent her a Facebook request, friend request. So that concerns he's trying to reach out and contact her.
Your Honor, in talking to my client, we have decided to address this issue head on. My client has an explanation for this that he would like to offer to the court.
Go ahead. Is he admitting to that?
Yes, sir.
Mr. Allen?
He is admitting to that, Your Honor. The explanation is. You want me to?
I can say it.
Okay.
It was a mistake. I push and remove and push add frame. That was simple. That's what I did.
Your Honor, he tried to eliminate the possibility of any contact. He saw that she popped up. He wanted to remove any possibility that he could have contact with her. That was his intentions. And
How did that even happen though?
Just
I mean,
done.
Okay.
big thumbs, Your Honor.
That, but
I was a mistake. I admitted though.
He didn't intend to contact her. There's no allegation that he actually made contact with her. Like I said, he wanted to eliminate the possibility of that. He made a mistake.
Nope.
Your Honor, in reporting the violation to us, I believe she told us that she had made an entirely new Facebook account, not using her name, and that was the account that sent a friend request to. She wasn't sure how he found that account, but he added her as a friend and she needs to report it.
Your Honor, the only thing I can provide is that when new accounts pop up, the suggested friends that pop up, he likely noticed that it was probably hers. He intended to remove it to eliminate any possibility of contact. He immediately, when he clicked add, he immediately went back and clicked remove. Realizing the mistake, he blocked her. Again, there's no allegation that he actually had contact with her. He doesn't want contact with her. He understands that he's on bond and he doesn't want to do anything to lose that. And
do not have
that's
or attempt to have direct or indirect contact with the above individual in person or through others by electronic communication, including but not limited to phone, email, texting, internet, or social media.
Well, Your Honor, if it was not under her name, I don't know how he could possibly have also known that it was her definitively.
Then why would he have attempted to remove it?
Because the possibility that it could have been, I imagine. He advises that it was her face. So he wanted to.
He knew.
Well, Your Honor, he is just providing an explanation as to why he wanted to eliminate the possibility of contact. It did pop up. He did remove it. He's asking that the court. He blocked her. He is asking that the court take that into consideration. He's asking, we are pleading with the court to allow him to remain out on bond at this time. And he was, for what it's worth, honest with the court about that. He is taking accountability for it.
Anything else? Tell
No,
you
Your
not to have contact. He sees her face. He attempts to make contact with her. He can't violate the bond that way. Just plain and simple. Defendant's bonds revoked. Defendant's remaining. Thank you. Court calls the case, people versus Victor Morris Gerard.
Your Honor, in regards to the probable cause conference, we're requesting an adjournment. There was still some outstanding discovery that we requested.
You have a green sheet. As to the bond violation.
As to the bond violation, Your Honor, I did have an opportunity to speak with Mr. Gerard. Your Honor, he takes full accountability. He's indicated to me that he has been struggling with depression, and obviously, now knowing that this issue is much bigger than we talked about treatment opportunities. In the report from Community Corrections, they did indicate that they have made a referral for CCOP on his behalf as well. He has not spoken with Mr. Brown to see where they are with that program, but I just asked the court to at least give us the opportunity to explore that option and see if we can get him into outpatient treatment.
No, you might be able to get him into outpatient treatment, but he's clearly in violation because they have had 4 successive tests where he's positive for cocaine, amphetamines, and then his last test positive for cocaine and alcohol, but before the confirmation test on the alcohol, he left the building.
And I did ask him about that, Your Honor. I think that was just a misunderstanding. He stated that he did not know that they needed him to stay in the building to do any other follow-up tests, but I've explained to him that once there is a positive alcohol test, that they require the confirmation test.
All right. Anything else?
Nothing else.
So I set it for May 6th, 9 a.m. At this point, defendant's bond is revoked.
Thank you.
Court calls case, people versus Justin Robinson.
Your Honor, I'm handing the court a green sheet now. We're asking for an adjournment in this matter. Mr. Swope has been having some medical issues, so he was in and out of the hospital. Well, he was in the hospital. We weren't able to have contact with him. Obviously, he's here. I'll confirm his contact information and see if we can figure out what's going on this case and come to a resolution with the people. We are in communications with them in regards to a resolution, but we have not been extended an offer yet.
Go ahead.
Your Honor, we think that before we get to the adjournment, we should perhaps address bond. There was the violation report sent out indicating that Mr. Swope was released and on April 12th. And that he was supposed to be reporting to community corrections, which he never did. He did not go to community corrections for intake, let alone the 2 times a week testing that he's supposed to undergo, Your Honor. My understanding is that Mr. Swope did not appear have money, Your Honor. So it does not appear that there is a legitimate reason for Mr. Swope not showing up. At the very least for intake, he will be putting up or to pay for some particular tests. And my understanding is that he'd still be able to test, he just might end up owing some money. So Your Honor, at this time, I believe that Mr. Swope is in violation of his bond conditions and that perhaps a would be appropriate. So that he came today, however, we have no idea whether he's been using substances during this time. It's been out. Or why he did not even show up for anything.
And Your Honor, I did have a conversation with the people in regards to that. She did ask what the reason for his failure to report was, and everything that she stated is correct. I spoke with Mr. Swope. He stated that he did not have any money and he thought that he was required to present money at community corrections. Now, if there's a change in the rule, I did tell him that we still encourage our clients to go inform community
He needs
corrections.
to go.
Yeah.
He just hasn't done anything.
Sure.
Is he working?
No, he's not, Your Honor.
If I were to test you right now, you're gonna test clean? Don't, you're not. I didn't think so. Mr. Adams. Your adjournment. I'll set this Probable cause conference for May 6th, 2025, 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
Thank you, Anna.
Court calls the case People versus Cynthia Lake Pier.
Good afternoon, Your Honor. David Shanby, Cynthia Lake Pier.
Ma'am, your name?
Cynthia Lake Pier.
Thank you. Plea form indicates that she's going to be pleading that there are going to be 2 counts added. Count 3 of operating while intoxicated, the 93-day offense. Count 4, resisting and obstructing attempt, the 1-year offense. On her successful plea to that, those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice or rights form?
She did.
First one.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
To
State your name.
Cynthia Lake Pier.
Now, understanding all of that, you still wish to plead guilty.
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
January 18, 2025, at the location of 9876 Main Street, Whitmore Lake, Northfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
Captain and Coke at Captain Joe's. I don't remember. Maybe.
All right. Were you stopped by the police or was there an accident?
It was a single car rollover accident, Your Honor.
Did the police arrive?
Yes.
Were you taken to the hospital?
Yes.
Was there a blood draw?
Yes.
And what were the results of the blood draw?
It was 0.253, Your Honor.
Ma'am, do you have any reason to dispute those blood test results?
No, sir.
All right. When the police did arrive and you were interacting with the police, what happened?
Did you attempt to kick one of the police officers?
Yes.
And at the time that you were attempting to kick the police officers, what were they trying to do?
Take me into the hospital.
They were trying to get you into the hospital, get help for you, and you tried to kick them. Is that correct?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
16th at 9 a.m. before Judge Shower.
June 16, 2025, 9
Yes.
a.m. before Judge Fresh Hour. And we'll continue.
Regarding bond,
Yes.
there is a key corrections report, maybe slightly concerning. How I read it, there was a missed test in the evening, and then the following morning, a late test with a very low alcohol, 0.006, I believe, which
What happened? I don't know why they didn't say this is a violation of civil progress report.
I had just received the,
Mr. Allen, on April 11th, you tested positive for alcohol.
Your Honor, this was the first time she's ever been on any type of sober link monitor. It's the first time she's ever had a criminal offense. And this was the very first day. You can see she missed the test on the night of the 10th, which is the same day she picked up the sober link. And then she missed the next morning, or tested positive the next morning in the 5 to 8 window the next morning. I believe it was just a process of her getting used to being tested.
I don't know what that means.
It means that alcohol is the undisputed heavyweight champion of the world. If she was drinking prior to that date, she had quit, and she may have still had some residue left over. She has had no positive tests since the first day of testing. And if she hasn't figured out a way to stop drinking successfully, She is going to be found out when she's either continuing on bond or when she's on probation. And we would have no objection to her continuing on the sober link as long as Judge Fresh Hours thinks necessary.
Well, except for the fact that I have an arraignment occurring in January 2025. Unless that date is wrong.
There was no, she was doing testing, random testing every week for 3 or 4 months, but there was no alcohol testing, regular alcohol testing. There was no sober link. There was no scram tether. There was nothing for like 3 months.
Yeah, but she was under an order not to consume alcohol.
I understand, Your Honor, and I'm not saying that she did. I'm saying that it looks like this was her first time ever on a sober link. And maybe it takes her a while or took her one day to realize what the expectations were. And she cannot have any alcohol of any kind to consume anything that would possibly cause a positive reading.
She knows she's not supposed to have alcohol.
I did not. I had a root canal. I was in the process of that. Only thing I had was penicillin. Honest to God.
I have
Is
to.
that what you really want to tell me?
I'm telling you the
If
honest to
you're, no,
God.
ma'am, is what you want to tell me is that on April 11th, you tested positive on a sober link because of a root canal?
I had no alcohol.
I've been doing this a minute.
I had
And if
no
that's what you
alcohol.
want to tell me, ma'am, I'm just asking you a straightforward question. Is that what you want to tell me?
Yes, sir.
Okay. Well, then I'm gonna let Judge Freshour handle her bond, but at this point, her bond is revoked, defendants remain.
Thank you, Your Honor.
And when I'm done with this document.
Can we get another
You want
date
another,
prior
you
to
want
the,
another round?
well, I want another date prior to the.
You want to
June.
still mess with me?
I want her to.
What, you know, I'd like to.
I under,
tell
you
this
and I are on the,
Now, no, what, go ahead, what?
you and I are on the same, you and I are on the same page.
Yes.
And actually, I asked Andrew to have her tested, deep testing. She's gonna be really mad when she hears
What
that,
is-
but I don't care.
do I have an interest?
It's May 19th at 9 a.m.
May 19th.
I think that's good. Thank you, Your Honor.
Are you done for today?
I am done.
That went off the rails real fast. You try to get a judge kicked off the case, you better come with receipts. Instead, this lawyer walked into court and walked straight into a wall. Judge Simpson doesn't play games. What would you have done in that courtroom? Let me know in the comments. And as always, stay smart, stay honest. This is Court Diaries. Catch y'all next time.